immigration attorney at the Volunteer Lawyers Project, and we're thrilled that you all came forward to the CLE because it's a really important recruitment tool that we use on an annual basis to get attorneys to represent non-citizens who are in removal proceedings. We do most of our work at the Federal Detention Facility in Batavia, which is about 40 miles east of here between Rochester and Buffalo, as you may know. It has a capacity for holding 660 adult men. There are no women held in Batavia, although occasionally we do represent detained women as well, but they are detained in the county facilities throughout the area, as well as in the eastern part of the state. So we have less of an ability to represent them, unfortunately, because of their distance. In terms of preparing them for trial and whatnot, we would have to go out to most of these facilities, and they tend to be far away, like at Allegheny, Chautauqua County, Cattaraugus County, Albany County, Clinton County. So we concentrate mostly on the men that are detained at Batavia. However, we also handle cases for people who are appearing before the court in Buffalo, right here at 130 Delaware, where the U.S. Attorney's Office is located, as well as people who are not in removal proceedings. We have a very active project representing people who are victims of human trafficking and other crimes in the United States, as well as unaccompanied minors. So from time to time we call on attorneys, particularly those who have some immigration experience, to handle those cases. Today we'll be concentrating just on two forms of relief, two defenses that exist in immigration removal proceedings. We chose these many years ago when we started this project because we thought that they were first of all, they're the most common forms of relief that we encounter, and secondly, it's easy for people who have never handled a case like this kind of to grasp what the standard of proof is. When we give you a case, we have screened it for statutory eligibility. We're not asking you, because we recognize that many of you don't practice in this field, we're not asking you to identify the remedies and whether someone is in fact deportable, first of all, whether they're properly placed in removal proceedings, whether there are other forms of relief, whether they're even eligible for the forms of relief. We have done all that screening. When we come to you, we're asking you to take the defense side. We've usually admitted that the person is removable from the United States, and we've pleaded that this would be the form of relief that we're going forward on, and that's when we get the pro bono attorneys involved. So we are very, very grateful to you for being a part of our project. I'd like to introduce my colleagues. There's many of us here, just so you know, because you may get a call from any one of us. Two other colleagues will be presenting today, but there's some that won't be. So Bob Graciano is a staff attorney who does work at Batavia and in Buffalo, removal defense. Emma Buchthal is our attorney who concentrates most of her time on human trafficking, victims of domestic violence and violence. Jessica Lazarin, who's in the back, also will be presenting, and she works with unaccompanied minors as well as doing the removal defense work in Batavia. And our newest attorney, I'm going to put her on the spot because she hasn't even started yet, is Desiree Lerv, who will be involved in representing people at the detention facility in Batavia. So I got everyone, right? Jocelyn Nieves is also sitting in the back, and she's one of our legal assistants. So we invited her to come. We're just missing one person who was supposed to come, but that's fine. Just so you know, there are restrooms inside the Bar Association. There is this one here, but those inside the Bar Association may be more comfortable, so you can go in there. Obviously, you've seen there's donuts and coffee, and hot water is being finicky, I understand. In your material, I put a flyer for what we call the Champions of Justice Bash. It's VLP and Legal Services for the Elderly's annual fundraiser. It's a lot of fun. This year we're having it at the Lafayette Hotel, lots of food and drink. We invite you to participate, get to know all of our staff, get to know other lawyers in the community who contribute to VLP by giving their services pro bono. VLP handles all kinds of civil legal services, not just obviously immigration. We do bankruptcy, we do family, we do tax issues, we do unemployment insurance. So we have attorneys from all over Western New York, and particularly Erie County, who are helping us by donating their services. And then there's two more comments I want to make. There's a sign-in sheet for CLE. Please sign in. The Bar Association no longer, the CLE committee no longer requires you sign out, but you have to sign in to get CLE credit. As well, in your material there is an evaluation sheet that is required for the CLE as well. Before you leave, just leave the evaluation sheet on a table somewhere and we'll pick it up. There's also, I think I copied it in yellow, a sheet that's called Attorney Questionnaire. It may be yellow, it may be pink, I'm not sure. It says, yes, Attorney Questionnaire. That's for my purposes or my staff's purposes, just to know a little bit more about you so that we can match you as best as possible with a case. I find it really useful if you have one to leave your business card with that, because sometimes the contact information will just get phone numbers, but it's sometimes easier to give people the information by email. So if you leave your business card, that would be really helpful. So those two pieces of paper, if you would be so kind as to leave them. Don't forget to sign in. And those are basically our preliminary points, I guess, our introductions. In the material you have on your left side, you will have mostly procedural stuff that deals with procedural issues. I will start the first presentation, what happens in immigration court, and that slide, that PowerPoint should be copied on the left side. All right, yeah. On the right side is mostly substantive law. That's where you're going to see the PowerPoints on cancellation of removal, one of the forms of relief that we have, as well as asylum and some asylum case law, just so you have a sense of it. We'll refer to our material. There's a lot of stuff in there. We hope you have a chance to look it over when either today or when you have a chance. So let's move forward so I can explain to you your role in our immigration process. Okay. So first of all, you need to understand who the players are, obviously, especially if you've never worked in the immigration field. We are going to toss out a lot of terminology about who is going to be your opposing counsel, who is holding your client, where your client is going. The key players in the process, first of all for us, is the Immigration and Customs Enforcement, which is part of the U.S. Department of Homeland Security. Once upon a time, many years ago, you may have heard of the Immigration and Naturalization Service. They used to have these functions, all under their INS umbrella. In 2003, after 9/11, the INS was disbanded and the Department of Homeland Security created. Under the umbrella of the Department of Homeland Security, there are 3 agencies that handle immigration-related matters. We deal most often with Immigration and Customs Enforcement. Enforcement and removal operations are the people who are holding non-citizens who are deportable. Those are the people who are running the detention facility in Batavia. The facility in Batavia is owned and operated by the U.S. government. There are many private facilities throughout the country that hold non-citizens for removal. But here we happen to have one that's government-owned, and it's run and operated by ERO. We deal less with Homeland Security investigations. They are the people who are going to be investigating things such as human trafficking, child pornography, crimes that are occurring in the United States. They also monitor students in the United States and whether they're following their visas properly. So either organization might be involved in our work, but we're dealing mostly with ERO. Okay, and there's a description below of ICE, as we call it for short. The Office of Chief Counsel of the Department of Homeland Security are the attorneys. They are the people that you will be seeing in court when you walk into the courtroom. They will be seated at a table opposite you and your client. Their job is to represent the government in removal proceedings, as well as advising and counseling the various branches of the Department of Homeland Security, and especially ICE. There's an Office of Attorneys in Batavia, and there's an Office of Attorneys in Buffalo. We have very good working relationships with them. We encourage you to contact them when you have cases before the courts. You can resolve lots of matters by talking to them. They are very open to speaking to our pro bono lawyers in advance of trials. We contact them when we're discussing bonds for our clients. What are they envisioning? What are we envisioning? Can we come to an agreement so that the judge can just issue a bond order? Is there going to be a fight? On the merits hearings, the individual hearings that you would be handling, you can call them and say, hey, what are the issues you're struggling with here? What do you think I need to convince you of so that you might not oppose a grant or you might go easy on my guy? Things of this sort. You can definitely reach them, and once we know who is handling the case, they often don't know until a couple of weeks before the trial, we can certainly give you their contact information, and we encourage you to speak to them. Citizenship and Immigration Services, you would probably deal with in terms of being a pro bono attorney for VLP on a very limited basis. They are the immigration benefits branch. They have no enforcement role. They are the people who are giving benefits to foreign-born nationals. They're issuing green cards, they're naturalizing people. So we don't deal with them on a regular basis if we're in removal, if we're dealing with removal matters. We might deal with them when we're dealing with victims of domestic violence, and we need to do those special applications that are available to them. Or if we're filing an asylum application for someone who is not in deportation proceedings. We rarely would give that kind of case to a pro bono lawyer, though. Most of the cases we give to pro bono lawyers are going to be people who are in removal proceedings. Customs and Border Protection are the people you see when you land at JFK or at any airport from abroad. It's the people at the Peace Bridge, the Rainbow Bridge, the Lewiston-Queenston Bridge. It includes the U.S. Border Patrol. They do play an enforcement role. So when a person is encountered by immigration authorities, they can be placed into removal proceedings either by ICE or by CBP. Those are the organizations that are writing up the charging documents and placing people in removal proceedings. Citizenship and Immigration Services does not get involved in that. And then, of course, the Immigration Court. Up until now, we've been talking about the U.S. Department of Homeland Security. The Immigration Courts are a branch of the U.S. Department of Justice's Executive Office for Immigration Review. It's an executive office. Judges are hired. They're not really appointed or elected like Title III judges. They are not ALJs and they are not Title III judges. They're their own kind of creation. The two judges in Batavia, and there is one judge in Buffalo with a vacancy that we keep hearing will be filled shortly but has not yet been filled. So these are the people that you will be appearing before in these cases that we refer to you. Okay, then I want to make sure we understand who your clients are. Who are the non-citizens that we're representing? These are technical terms. These are not layperson's terms. Lay people use these words differently than we do as immigration lawyers, so I want to make sure that we're very clear. A non-immigrant is a person who is in the United States lawfully, but temporarily. The non-immigrants are going to be your students that are studying here temporarily. They are expected to go home after they have completed what they came to complete. When they come here on their visas are very specific. They are tied to a certain university, they're tied to a certain employer, they're tied to tourism purposes, and those are the only things that they're allowed to do on those visas. But they are people who have entered the United States lawfully. They've been allowed to come for a temporary stay in the United States to complete a very specific goal. Immigrants are the people who have been admitted to the United States to live and work here permanently. They are often what we call your green card holders or your lawful permanent residents, LPRs is what we always refer to them. The green card is not a green card anymore. I think it's getting greenish again after being pink for years. But they're lawful permanent residents. They have the right to live and work permanently in the United States. However, they are subject to deportation from the United States under certain circumstances. Only United States citizens, whether by birth or naturalization, can never be deported. Everyone else who is a non-citizen can be deported. We often get people, but he's a refugee, you can't deport him. Oh, yes, we can. Okay? He's got a green card, he's had it for 50 years, you can't deport him. Oh, yes, we can. Under the laws of the United States, only citizens cannot be deported. Green card holders can be deported, and many of your clients will be green card holders. They will be, some of them, long-term green card holders. Some of them came here as children and then violated the law, because a green card holder, an LPR, can be deported for basically two reasons. One is most convictions for criminal offenses, and the second is being outside of the United States too long. So those are the two reasons that we might find a lawful permanent resident in removal proceedings. We will find non-immigrants in removal proceedings generally because they have violated the terms of their non-immigrant visa. They came here with a tourist visa and they worked. That's a no-no. They came here as a student and they worked. You can't do that under most circumstances. They overstayed their period of authorized stay. The tourists, they come as tourists, maybe the border agents, when they came in at JFK, gave them 60 days. And now they've been here 90 days or a year or 5 years. If they're encountered by immigration, they will end up in deportation proceedings. Okay? And what is key there, a lot of people get very confused and say they overstayed their visa. It's not their visas that they overstayed. It's a little card called an I-94 that they're given when they come into the United States that tells them how long they can remain in the United States. The visa is simply a travel document. The visa allows someone to come into the United States. It does not tell them how long they can be here. There are people who have 10-year visas. Doesn't mean they get to stay in the U.S. for 10 years. It means the visa is valid for 10 years as long as they're compliant. It means every time they come, if they're allowed to stay 60 days, they leave before 60 days, and then they can come back on another vacation. It's the I-94 that controls, as well as other guidelines like staying in status. If you're a student, you have to be a full-time student at the university that issued your documentation. You can't just move from one university to another. So we encounter people who have violated their visas or overstayed their periods of authorized admission at the facility, some of whom may be applying for asylum because they fear going back. And those are the people that we would call upon you perhaps to represent. The removal process, courts order the removal of a person. It's not up to the arresting officer in most circumstances. The due process protections do apply. They're administrative type hearings, quasi-judicial as they call them, but there are due process protections. However, the rules of evidence are very loosely applied, and there is no right to an attorney at government expense. That's why we need you so badly. In other words, yes, there is a right to an attorney in a removal proceedings. All non-citizens are advised of that right by the court. However, there are no, if you will, public defenders, legal aid, because these are viewed as civil proceedings, not criminal proceedings. At Batavia, they look very criminal. They're wearing uniforms. They're categorized by the seriousness of their criminal offenses, if they have any, but there is no absolute right to an attorney. So a person comes into removal proceedings or deportation proceedings, usually by one of these forms. They're arrested at the border, coming in, and the CBP officer finds that they have no right to come into the United States, so they are arrested and then perhaps detained. In most cases, we detain them at a place like Batavia. Or ICE might encounter them in some capacity. ICE regularly does screenings of all inmates in criminal custody to determine their citizenship. If they find they are not citizens of the United States, they will put holds or detainers on them so that the criminal facility, let's say the state facility, cannot release them when their release date comes up, but they must be held in order to be transferred to immigration custody. Okay, this is a very controversial process, and there are some jurisdictions in the United States who have decided they're no longer going to comply with that, but right now that's the way it still works in this part of the state. Once they are arrested, the first decision they make is whether the person will be held in custody at a place like Batavia. Some people are subject to what we call mandatory custody. General rule of thumb, a non-citizen with a criminal conviction will be subject to mandatory custody. That means they must be held during the pendency of their removal proceedings, and they're not eligible for bond. Other times, if they have no criminal convictions, ICE or CBP will decide to set a bond on them, which would allow for their release if they can post the bond. There are circumstances in which people are not held. Perhaps if one of these agencies feels a person has very strong ties to the United States, is a long-term permanent resident, is not a danger to the community, is not a flight risk, they may not detain them. They don't detain women with children. If they encounter a family, for example, they will detain the father, the man, and any sons over 18. But they will usually let the mother go with her children to care for her children, and they won't detain her. That's unique to this jurisdiction. That is not countrywide. There are facilities that hold entire families. The closest to us here in Buffalo is in Berks, Pennsylvania. Once that determination is made, they issue a charging document. The charging document that you have in your material that is most common is the notice to appear. It sets forth the charges that a person has against them, that have been set against them. Criminal convictions would be set forth in that document, but not all criminal convictions necessarily appear on that document. Sometimes they will choose the criminal convictions that make someone removable, but not add all of them because they don't really need all of them. They've got one is enough to make the person removable. Sometimes they can be asylum-only proceedings. And those, a little bit more technical, but we do encounter those from time to time. Once they are placed in removal proceedings and they appear before the judge, it's usually a three-step process. The master calendars, which are a lot like arraignments in the criminal process, this is where you go forward, you plead to the charges that have been imposed against your client. If your client is indeed deportable, you ask for a form of relief. The individual hearing or the trial date gets set. There may be some discussion of whether evidence is admissible at that point, especially the government's evidence, which they have usually put forth to prove that the person is in fact deportable, like certified criminal records. There may be a bond redetermination hearing if your person is not subject to mandatory custody. You may be arguing about the bond amount being too high and you wanting it lowered. Once there's an individual hearing, usually decisions as to whether the person will be ordered deported or not are made at that individual hearing by an oral decision. After that, after a decision has been issued by the judge, there are 30 days to appeal to the Board of Immigration Appeals, which is also part of the DOJ's Executive Office for Immigration Review. After the Board of Immigration Appeals, you can go into the Second Circuit Court of Appeals, but only on matters or questions of law or fact. You cannot go in under Real ID. You can no longer go in on immigration cases on matters of discretion. And a lot of immigration cases are discretionary. Okay, so these are the ways arrests happen. I've mentioned a couple. Border Patrol and checkpoints. People coming over the bridges, not being authorized to come in. You can sometimes get local law enforcement stopping a car. The police pull somebody over, the sheriff pulls somebody over, they notice people are looking foreign-born. They call Border Patrol. They like to say, we're calling Border Patrol for translation purposes, but usually it results in an arrest. They scour the prisons, as I mentioned. There are concerned citizens that make phone calls. I understand on Grand Island in particular that if they see any odd things happening across the river, they might call Border Patrol. And people present themselves at USCIS in order to do something on their paperwork, and USCIS, even though it has no enforcement role, might call ICE, which is on the second floor, and say, I think you need to come down and take a look at this. It looks like it's a little funny. And that might land the person in removal proceedings. As I mentioned, some people are not permitted to get a bond. The courts have no jurisdiction over bonds. First, it's people who are deemed inadmissible to the United States, and they're deemed arriving aliens. These are people who show up on our borders, either at JFK Airport or at the Rainbow Bridge. They're asking to be admitted to the United States. The agent says, you're not admissible, there's something wrong with your paperwork, or we're looking in our database and we see you have a conviction. If they say at that point that they're afraid to go back to their native country because they believe they will be persecuted, they will be taken into custody, placed in a detention facility like Batavia where they can go forward on an asylum case, but they will not be allowed to get a bond. They might be paroled out of the facility, but they will not get a bond. The other people who will not be allowed to have a bond fall into these categories. As I said, general rule of thumb on the safe side is almost every criminal conviction makes a non-citizen subject to mandatory custody. Most of our clients are subject to mandatory custody. If we think our client can get a bond, we will certainly let you know. We may take care of the bond hearing, or we may ask you to if you'd like to have that experience. And these laws apply to anyone who was taken into custody after that date, which was a change in the law that made these provisions effective. Okay, so if bond can be set, in the first instance it will be the arresting agency that will set the bond, ICE or CBP that will set the bond. They have to first determine whether the person is a flight risk. They're looking at these factors to determine whether someone is a flight risk. In setting the bond, the amount of the bond. The more a flight risk, the higher the bond or no bond. Obviously, the lower the flight risk, the better the bond. They're also looking at whether someone is a danger to the community. They may have a criminal history, but does not subject them to removal, so they're looking at that. A very classic case would be DWI. Driving while intoxicated still is an offense in the United States that does not subject a non-citizen to deportation. There's a lot of controversy, and that may change if the immigration laws ever change, but right now a simple DWI does not lead to deportation charges. However, if someone has a DWI and they're requesting a bond, the judge is certainly going to look at whether this person is a danger to the community in setting the bond. Okay, in order to go into removal proceedings under Immigration and Nationality Act, Section 240, which are the standard removal proceedings that most of the clients we represent and would ask you to represent would be in, they're going to have a packet of information that is served on them. And usually that packet of information will be given to you when you take the case. We might not have a lot yet, but we will at least usually have this, which will involve the notice to appear, a notice that they put together with information about where the person is located, which is usually a detention facility unless they haven't been, they're not being held, and the custody determination papers. These are the papers that tell us whether a bond has been set or not. If the government wishes to add additional charges, I mentioned earlier that oftentimes the notice to appear will simply have one offense, one criminal offense listed, because they figure with that one criminal offense the person is deportable. But at some point they may want to add some charges, like they found other criminal convictions that the person has in other jurisdictions. It took them a little longer to get it together. They can add additional charges by issuing this document. Okay, it's very simple for them to add additional removal charges. Okay, something important to understand is the concepts of inadmissibility and deportation. They all fall under the umbrella of removal from the United States. But they're technically two different forms by which the government removes people, and they make a difference in terms of rights. Inadmissible, as I mentioned earlier, is a person who's knocking on the door of the United States, and they're not allowed to come in. Or it's the person who crossed the border unlawfully, without documentation, and is encountered inside the United States. Those folks are going to be in what we call proceedings under Section 212 of the immigration law. They're going to be charged as inadmissible. The difference with that is that the burden of proof is on the applicant in court to prove that they are indeed admissible to the United States if they want to avoid being inadmissible. There are less rights generally if you're inadmissible. Deportation is people who have entered the United States lawfully. Those people I told you earlier came with a tourist visa, their student visas, the people who got permanent residency. They're being expelled from the United States. In those cases, the burden of proof is on the government to prove that they are in fact deportable. And the charges of deportation are contained in Section 237. They're very technical distinctions, but they're worth knowing. The grounds of inadmissibility are not the same always as the grounds of deportability. And this becomes important depending on the applications you're making before an immigration court or before CIS. The other thing to keep in mind is that the government has the burden of proving that someone is deportable. And that's really important when the government is charging someone with being deportable on a criminal basis. For example, you can be deported for possession, simple possession of more than 30 grams of marijuana. But you're not deportable if it's less than 30 grams possession. And I have had cases terminated because the government can't meet its burden of proof, when the government can't come up with the quantity of marijuana a person was convicted of. They might have the conviction record. Florida, for example, when you're convicted in Florida, they'll tell you you were convicted of a crime involving 10 to 30 grams of marijuana possession. I'll say, great, so it could have been 29 or less, and it could have been 30 or more. If the government can't come up with evidence showing exactly the quantity, then the person is not even deportable from the United States. The government has to prove that. But if it's the reverse, if the person, say a Canadian, wanted to come into the United States, he or she would have to prove that they can come in, that they qualify to come in. So they have to come up with the evidence that they weren't convicted of the crime that the U.S. government says they were convicted of.
But how much is 30 grams?
I don't know, 30 grams is 30 grams. I mean, if you're asking me if it's a joint or two, I don't know. It's 30 grams.
Okay.
If someone knows, they're welcome to answer that. I just don't know. Okay, these are the types of, some of the defenses that exist against removal. Again, we'll be talking about the two top ones today. Okay, this is a special provision that allows people who have been here 10 years or longer, physically present in the United States. They can prove a bunch of things other than that. This is people who can get green cards, that the law would actually allow them to become permanent residents. They might be married to a U.S. citizen and have entered the United States lawfully. They can apply for what's called adjustment of status in removal proceedings. This is the fallback option. If someone has no defense against deportation, but they don't want to be ordered deported, they can leave voluntarily. And then there are cases in which someone might even be naturalized in removal proceedings. And I've done a number of those where someone, in the alternative, instead of applying for a defense, we went right to naturalization because, for example, the criminal conviction was so old that the person could qualify for naturalization as a defense against deportation. All right, at Batavia, basically the master calendars are held Monday through Thursday, and those address these preliminary matters that I talked about. Bonds can be addressed, pleadings. The government will often put in evidence, especially when they have the burden of proof. They'll put in the evidence, the conviction records, anything else they want you to consider. If someone came in on a false visa, false passport, photo imposed passport, things of that sort, some legal issues might be discussed. These are very brief hearings. We're usually covering those. We are usually covering these for our pro bono lawyers. We're not asking them to get involved at this preliminary point only because it takes some background in immigration law. However, if you want to handle a bond hearing or you want to handle a master hearing, we'd be happy to put you in court and walk you through what you have to say. So that's not a problem, but we don't usually expect you to appear at that stage. The individual hearing, this is what we'll be asking you to handle. This is what we also call the trial. So it's actually preparing the case to present to the judge the evidence that the person is statutorily qualified for the relief he or she is seeking and discretionarily eligible for the relief he or she is seeking. And as I said, usually at the end of the merits hearing or the individual hearing, lots of terms for the trial, the immigration judge will issue an oral decision. Sometimes they can hold the decision under advisement, call you back for an oral decision. Sometimes, particularly the judge in Buffalo, issues written decisions. So you would not get a decision that day. In Batavia, it's almost always an oral decision on that date. Okay, again, we don't follow the rules of evidence, but we like our lawyers to know them well enough so that they can make objections. We like the records to be made very well because, again, we can go to the Board of Immigration Appeals on appeal, but we can't get into the Second Circuit unless it's a matter of law or a factual matter. And so making the record becomes critical because if it's only on discretion, the federal courts do not have jurisdiction over immigration appeals. All documents must be translated into English. Certainly if we give you a client who doesn't speak a language that you speak, we will try to have an interpreter available to help you communicate with that client, as well as to translate written material. We're not generally in the business of translating like 6-page documents, so it's very hard to find translators who are willing to do that for free. Once a decision is granted by an immigration judge or the board, obviously the respondent, that is the non-citizen you're representing, the non-citizen in proceedings, will be released from custody if they're in custody, and the proceedings will be terminated. That's it. You've won your case. It can happen at the immigration judge level, or it can happen on appeal if we appeal. And we appeal almost every case, assuming the client wants to appeal. Some clients don't want to. They don't want to remain in detention anymore. If relief is denied and a removal order is issued, a final removal order, no appeals, ERO tries to acquire a travel document and makes arrangements to remove the person to their country of nationality. If the person has a valid passport, that is a perfectly acceptable travel document for deportation purposes, and the ERO needs not do anything more. If the person does not have a valid passport, with the exceptions of Mexico and the Dominican Republic will take expired passports, every other nation requires that its people have a travel document so they can be admitted into their own country. And that means that ERO has to communicate with the consulate of that country in order to obtain the travel document. Currently in the United States, there is only one country to which we don't deport as a rule, and that is Cuba, because we have no diplomatic relations with Cuba. We haven't had them since 1959, so we cannot obtain travel documents for Cuban nationals. Every other country we can and do deport to, even times when they're at war, or there are enemies, or we don't like them. There's a lot of people running around believing if they're refugees, their countries won't take them. There's people who believe, well, because they're at war, they won't take me, or we've just had an earthquake, they won't take us. That's not the case. There are times when the U.S. government decides to have a moratorium, like after the Haitian earthquake, they did not remove Haitians for humanitarian reasons. That's different. But by and large, the rule of thumb is almost any person can be deported. How long it takes depends on the cooperation of that country. There are countries that are notoriously slow in issuing travel documents. But the only country, as a rule, we don't deport to is Cuba. And what the law says is if they can't be removed within 90 days, they are supposed to go through a special process before ICE to prove they're not a danger to the community or a flight risk, and they can be released, because the Supreme Court has said we cannot hold people civilly indefinitely. And this happened after some Cubans years ago were held for 14 years civilly because they couldn't be deported, and therefore there were riots in Atlanta and all sorts of problems. Yes?
So if you have refugees, let's say from Iran here,
They can be deported.
but they're political refugees.
Doesn't matter. They can reapply for asylum, and maybe they'll win, maybe they won't. Country conditions change. But as I think I mentioned, refugees can be deported. It's a big myth. People think, oh, we gave you asylum, your poor person's going to be persecuted. Doesn't matter. If they violate the law and they're subject to removal, they can be deported. Only citizens can't be deported. Okay? So they can be subject to removal proceedings. Then the question becomes whether they can actually be physically deported. And as I said, the only country I can guarantee you is Cuba. Every other country, the risk is they will be put on a plane to that country one day. Okay, the appellate rights very quickly, 30 days to file with the Board of Immigration Appeals. We ask all our attorneys when they get the oral decision of the judge will ask you, do you reserve appeal? Please say yes. Even if your client is getting antsy and saying now, because they do that sometimes, say yes. And tell your client, I'm going to do it because you might change your mind when you're calmer. If you do not reserve appeal, it is forever waived. It is very difficult under the current case law to recoup your appellate rights if you've waived them. So we always ask that you reserve it. After 30 days, if you don't file a notice of appeal, your client will be deported. And in some cases, we have moved to have the judge to to withdraw our reservation of appeal so that the client could be deported quicker because he's absolutely sure he doesn't want to be deported. Again, we can go into the Second Circuit on a petition for review 30 days after a Board of Immigration Appeals decision, but they're very limited. We take only certain cases to the Second Circuit because we need pro bono lawyers to do them, and we're usually counting on the big New York City firms. They tend to do our Second Circuit appeals. NYU Law School has also done a number of Second Circuit appeals for us, but it's usually the big firms in New York or Washington, D.C. that will take those for us. And they have to be on legal or factual issues. Okay, so rules of thumb. Talk to your client. Anytime you're going to go into court, talk to your client. Know what the charges are against your client. Look at any evidence he or she has given you. You need to file a notice of appearance. Jessica's going to go into that in detail. There's all sorts of new rules that you all need to know about if you're going to represent someone in immigration court. There are some court rules that you should be familiar with. I gave you the website for the rules in your material. I just did one little excerpt of this massive book of court rules. It's in your material, but attached to that there's a little piece of paper that tells you the website where you can go look at the immigration court practice rules. Okay? The court will entertain telephonic appearances. You don't want to drive all the way to Batavia. It's a preliminary hearing, a master hearing. They will entertain motions to appear telephonically, but if you call the court on a cell phone, they'll hang up on you. You have to be on a landline. And don't come late for court, don't miss deadlines. We're very serious in immigration court about punctuality and deadlines. I don't practice in other courts, so I just don't know. But I know in the past I've had lawyers who've told me that in certain courts you can show up when you want kind of thing. That's not the case in immigration court. And one thing we're going to add to this is please bear in mind if we give you the case of someone who's detained, we would like you to complete it as fast as possible. We realize you have to prepare for the case. That's fine to tell the judge, no, I need 30 days or 45 days to prepare. But don't expect to take a trial and say, oh, can you set it for 6 months? First of all, the judge in a detained case setting won't do that. They're under incredible pressure to get these cases through the system. These detaining people cost us $160 a day. The taxpayer pays about $160 a day to keep someone in jail. Secondly, this is civil proceedings. These people have served their time for criminal convictions. They've served their time, they've been punished. They're sitting in a detention facility civilly. And a lot of them are very anxious to get out. We had one guy who was paying rent on a trailer home, trying to keep up with his rent payments, so he would have a place to go home to when he was done. We had a lawyer who kept asking for continuances. Finally, we took it over because it just wasn't fair to our client. So we do ask you if you commit to the case. We'll usually be able to tell you when we think the trial will be because it's usually about 2 or 3 months, maybe sometimes less after the master. So we can give you an idea and we'll ask you what dates you have conflicts because the judges will respect your conflicts. But don't expect it to be, to keep getting continuances. It's just not fair to our clients. Yes?
As we prepare for the case, are oftentimes non-party witnesses involved, or what?
Yes.
If you could just describe a little bit
Yes.
what you
When we go into the substantive law, we're going to talk a lot about who the witnesses will be for each kind of case. Yes, we expect witnesses most of the time. Asylum cases, less likely because there's not usually someone who's witnessed the mistreatment in the foreign country. But in the cancellation cases, most definitely.
And then, sorry,
No, go ahead.
do we have the ability to subpoena witnesses?
There is a right to subpoena.
Okay.
You do have a right to subpoena. It's very rarely done. I usually, when I've done motions to subpoena, it's been for documents
Okay.
that some agency won't give me and I need for my case.
And then do we have the opportunity to speak in privilege with the client?
Oh,
or is
absolutely.
everything
Absolutely.
monitored?
Absolutely. No, nothing. They are not monitored. There's a visitation room in Batavia where you can speak to the person openly. Phone calling your client in Batavia is virtually impossible. Don't count on phone calls.
Okay.
The women in detention, it's much easier to contact them by telephone, and I'm assuming they're not monitored. In Batavia, they have assured us that they're not monitoring the visitation rooms where the attorneys are speaking. I've certainly never encountered that kind of situation. Yes?
Well, I have 2 questions. I mean, wouldn't the asylum case take a little bit longer than 2 or 3 months to prepare if you're getting documents from foreign
If he's
country?
ideally, we'd love to have more time, but if they're detained, we just can't. We can't.
Okay.
Detained, you just got to work as quickly and as well as you can.
So do you find that then the asylum cases aren't as strong or aren't
We
as
try not-
provable?
No, we try to do a darn good job in that period of time.
Okay. And then,
You just gotta
for
work
someone that's
faster.
not detained, wouldn't the docket be pushed out further,
When they're not
Well,
detained, the
I mean, like-
dockets are much more.
like a year?
It could be a year. Now with one judge, yes, they're very long. If they hire the new judge, they may go back to what they were when there were 2 judges in Buffalo, which is about 6 months.
Is it a live judge? And
Yeah, they're live.
okay, I only ask that because Pittsburgh does
Yeah,
telephonic, so.
some people do they do video
Video,
teleconferences,
sorry,
especially with
yeah.
the women. They do it by VTC, but the men in Batavia are all live. They're held in the facility, the court is in the facility. It's all in one place. Okay, again, talk to Chief Counsel's office. They're really, really good to our pro bono lawyers. They will not hang you out to dry. I've never seen them pull the wool over someone because they know you don't have a lot of experience. And if they ever did that, we'd want to know. There was a case once where something got really complicated on the pro bono lawyer, and the judge realized what had just happened. And he said to the pro bono lawyer, I'm going to pause the proceedings right here. I'm going to give you a continuance. You need to go talk to Sophie, because this case has just taken a turn that is really... It had been a remand from the Board of Immigration Appeals, and the guy, when he was testifying, said he'd left the country and come back. And under the law, if you leave the country while your case is on appeal, you basically removed yourself, and the court would no longer have jurisdiction. It was a mess. And the pro bono attorney I didn't know what was going on, but the judge just said, we're stopping. And then I took the case back over. Again, deportation to people is a really serious, serious punishment. Especially people who have been permanent residents of the United States. They've established their lives here. Some of these people have been here since they were children. They do not speak the language of the native country from which they come. Their parents are here. They've got wives. They've got children. Their life is here. Some may face going to encounter very serious persecution and torture in their native countries if they're deported. So even though it's a civil proceeding, it is very serious, and these individuals are extremely, extremely grateful for whatever help they can get. So that's it for me. I am going to turn this over to Bob, who is going to talk to you about asylum, and he will address your questions. Both of them will address your questions in much more detail about what kind of evidence you'll want in these cases.